Hello, thank you for joining Hub International today as we discuss and explore nuclear verdicts, and more importantly, as we give you guidance and suggestions on better ways to help you prepare for that type of event. The title of this is You versus Plaintiff Attorneys. We'll give you a lot more information than that. The next slide, please. I'm going to start by introducing myself. I'm Jerry Gillikin. I'm a moderator. I'm Vice President of Hub International. I've been handling insurance for the motor carrier industry for 30 years. Let me back up and tell you how I got here. Like we all got here some odd way. I was loading trucks in college and saw the guys walking around with a clipboard and a tie and making a lot more money than me. I went, that's what I need to be doing. So when I got my degree, I got that job at Roadway Express, and I found out it's not that easy. A headhunter called and said, do you want to work on insurance for the transportation industry? And I really said, yes, I'll do anything else. It's odd how we got here, but there's so many people at Hub that have worked in or around transportation. To that point, a lot of people's husbands are even drivers. To that point, the guy that's next door to me here owned a trucking company, so we know what's going on. We have empathy for the people we deal with every day. And I know John and Rob and Chris can tell you similar stories. So I'm going to introduce the rest of the professionals that are working with us on here because I think their background will tell you why they're important on this call today. We'll start with Chris Easley. Chris has worked in this industry for 37 years, 16 with national insurance companies, and another 20 or 21 with large brokerages. My note I made to myself was, there's not many people you'll find in this industry that are experts at all these areas. So I pulled a few that are pretty important, like regulatory compliance, fleet analysis, safety program audits, mock DOT audits, and pretty importantly, DOT safety rating appeals. Not everybody can do that, and safety training. And on a side note, Chris told me that he has now done, I think, over 250 driver safety meetings. Folks,
that would be a comfortable estimate.
That's a lot of early Saturday mornings, isn't it?
Yeah.
I'll also introduce you to John Libertor. I'm glad to do it. He's been a friend of mine for over 20 years. John is a founder of Primacy Risk Services, and literally we both worked at Progressive Insurance several decades ago. We don't want to talk about those old days, but that's where I knew him from. But he worked for one of the largest fleets in Texas as a risk manager. He's worked for 2 large brokers in risk management and in claims. And now he finally got to his true passion, which is creating the claim firm that can make a difference. And as you'll hear from John today, you'll hear his passion on why he does what he does, and he is making a difference. And lastly, not least by any means, let me introduce you to Rob Thornburg. Rob's a trial attorney with Frost, Todd Brown in Indiana. He's a member of their mobility and transportation industry team with extensive experience representing motor carriers and transportation companies. Let me pause there and say, when you talk to a trucking company, they say, well, we have an attorney. Do you have Rob? Do you have somebody that knows this every day in and out? I think it's pretty important. So back to his introduction, he successfully tried and resolved thousands of cases in 27 states and throughout the Midwest involving catastrophic injury and death. He's a super lawyer, and he's been selected for the inclusion of the best lawyers in America for defense of personal injury litigation. In other words, this isn't Rob's first rodeo. Next slide. So here's our agenda for today. We'll talk a little bit about nuclear verdicts. Most of you have heard this so many times now. There's nothing new we can show you about what it is. But for those of you who don't know it, we'll give you a few statistics that'll catch your attention. We'll go to the pre-accident fundamentals with Chris, and then John will take the post-accident fundamentals. Rob will go over the jurisdictional factors affecting the verdicts, and then I'll try to wrap it up with some comprehensive solutions, because we're not here to tell you about nuclear verdicts. We're here to tell you how to prepare for them, what to do when it happens. So next slide, please. So nuclear verdicts have been around for a long time. They're kind of defined as jury awards surpassing $10 million. They're often way more than 10 million. We've seen some pretty crazy ones, but they stem from serious crashes involving injury and death. I'll also tell you they stem from motor carriers doing something wrong. And when it's blatantly wrong, those jury awards can get pretty high. Rob can tell us more about that later. It's been part of our legal landscape since 2006, but I got to tell you, in 2006, we didn't talk about it much because it wasn't happening like this. And today, well, the last bullet point here, number of cases with verdicts over 1 million has increased 235% from 2012 to 2019. If somebody had done another statistic on 2019 to 2021, it's probably gone another 235%. So our clients are in greater risk than ever of bankruptcy or being dissolved because of nuclear verdicts. There's just not enough insurance you can buy, which is part of what we're here to talk about today. We're going to help a lot of our clients, prospective clients, find a way to get more insurance. We'll talk more about that. Average verdict size in a lawsuit above $1 million involving a truck crash has increased 1,000% from 2010 to 2018. It was an average of 2.3, and now it's 22.3. Not many people are carrying $22.3 million in insurance. The median settlement in the top 50 U.S. verdicts has doubled in the last several years, 28 million in 14 to 54 million today. And lastly, if you haven't heard, in the last couple of weeks, we've finally seen $1 billion verdict out of Florida against a trucking company, or maybe two trucking companies. I want to talk to you a little bit about the factors contributing to these oversized jury awards. We'll start with inadequate compliance. And all these things are things that Chris can touch on later. John may talk about how it affects the way a claim is handled. But there are also things that we can show you how to help you with some of our tools. So inadequate compliance could be anything small, like not keeping up with your MCS 150, you're not doing annual reviews of your drivers, or it could be big things like a CSA basic that's an alert for things like speeding and seatbelts that's not being corrected. Negligent hiring is the second one on the chart here, and they can include things like hiring drivers that don't meet your guidelines or hiring drivers that shouldn't be on the road, period. Lack of equipment maintenance. I see things that to me are dangerous with way too many violations for brakes and tires, because we go in with a good case, we hand it over to the claims people, and they say, well, it's a good case, but it shows here we're having a violation every day on tires. So it's really hard to defend the motor carrier as being really good. Don't worry, everything's perfect here. We have to be in good position to be able to fight for you. The next one is negligent contracting. Now that could be things like your contracts with shippers. What have you agreed to in there? Contracts with brokers. Have you read those? And contracts with your independent contractors. Very, very important because everybody's watching that. Each of these can cause more trouble than you might imagine. So they must be carefully reviewed and often. And then there's improper onboarding. And that's, again, very important. Today, anytime we can hire a driver, we think, all right, it's a win. But if we hire them incorrectly or don't do the paperwork correctly, it becomes a huge red flag that somewhere down the road, an adjuster or an attorney will have to try to explain why we did what we did. Next slide, please. And then we've often heard, again, in transport topics and other place, the dirty five. I don't really love the word dirty five, but I understand where they're getting at. What are the things these plaintiff attorneys are looking for so they can prove this took place? When they grab one of these, they're on that claim. They're not going to settle it. They're going to fight it. So we have to stay away from them, starting with fatigue. And that can be your hours of service. But what I would say is they don't have to prove that you retired. They have to create doubt to that jury, and then all of a sudden we've got a problem. Distracted driving can be things like being on the phone, eating, etc. We know that you shouldn't be doing, but when you get a case and they can prove by checking the records you're on the phone, we've got a tough time fighting that claim. There's lack of equipment maintenance, as we talked about before, tires, brakes, but it could be anything. But one thing I've always said is, if you saw a vehicle maintenance basic that's in an alert, and they said, no, but it's almost all just lights and lamps and things like that, the minor things. Well, it's in an alert status, and now we've made the argument for the plaintiff attorney. We have to fight our way back out of it. So again, if you want to have the best chance to be able to fight a claim and win when you do fight it, we have to have the table set correctly, doing everything right beforehand. And then driving under the influence of drugs and alcohol. I don't think I really need to talk about that one. We understand that's going to be a problem. and then inexperienced or improperly trained drivers. Well, again, that we've seen some huge lawsuits over trainees out there that weren't being trained properly. For clarification, most trucking companies don't have inexperienced drivers and trainees. Most insurance don't allow it, but we have many clients that do. So if you do it, it's just a lot more work to make sure you do it right. Let's train them correctly. Let's make sure all the paperwork's done like it should be, and the insurance company buys off on this, and then it won't be a problem. But if you're just a 30-unit fleet that's going to try somebody out, that's going to be a problem without having it documented and done correctly. Next slide, please. I'm going to turn this over to Chris and let him run you through the pre-accident fundamentals. Chris, take it.
Thanks, Jerry. And let's begin with this slide here. What we're looking at is a timeline, a chronology, if you will. And what I want everybody to focus on is the event, the crisis. What my specialty is to the left of bang, and it's a concept of intervention and prevention of accidents. So you look at this timeline and you see some of the labels that we have here: early warning signs of a potential accident, opportunities to intervene and mitigate, escalation toward a crisis event. If you think about typical scenarios, this could be represented by a driver who has too many violations, either moving violations or CSA roadside violations. When those violations come to your attention, those are early warning signs. Those are indications that you need to take action, not ignore them. So then we move to the opportunities to intervene and mitigate. You really have to step up your game and make sure that you have some type of system in place to intervene, coach, counsel the driver. I hesitate to use the word discipline. It's a rather commonly used term. Certainly the insurance carriers like to see that type of terminology because they want to make sure that their policyholders are being proactive toward drivers showing warning signs. And then we have escalation toward a crisis event. It doesn't happen all the time, but unfortunately it comes out at the worst time, and that's during a civil trial. Why didn't you do anything to address driver John Doe before the accident? So some of the other concepts we want to talk about left of bang include awareness training, not only for the drivers, but also for the back office, policies, procedures, intervention, and threat management. To the right of bang, this is the expertise of people like my friend John Libertor. They help us to come up with strategies for response and recovery so that we can resume normal operations as quickly as possible. It's not just an automatic pick up the phone and report the claim. There's a couple of details and nuances involved with post-event strategy that can really help you should you be caught up in any type of civil action. Let's go with that next slide. So are you prepared for a discovery demand? And there's two D words I want to talk about. First of all, deposition and discovery. And these are things my friend Robert will talk about here in a few slides, but there's a difference, I should say. Discovery is a demand to produce records and any type of documentation consistent with the civil action suit. So to prepare the average trucking company, motor carrier, you want to establish and follow uniform and consistent driver hiring and onboarding procedures. And what I find in my particular practice in my region is the smaller the company, the smaller fleet size, the less consistency that we see. So some steps to consider include make sure your back office team knows and understands the commercial driver qualification requirements. And those are found under parts 383 and 391 of the Federal Motor Carrier Safety Regulations. Also research and establish onboarding procedures and driver file and record keeping systems. The key word for that bullet point in my estimation is systems, because many companies don't bother to establish a hiring and onboarding system. And here's an example. Your record keeping system can be anything ranging from hard copy files to electronic file uploading, or perhaps even something in between, some type of hybrid model. But what we see too often is when the hiring person leaves the company and somebody else is hired, they jump to a completely different system for hiring and onboarding. You want to be very careful about that. And as any business owner, the way you want to design your system is for the seat, not for the individual. So whoever occupies that seat for hiring and onboarding should follow your system, not their own version of a hiring and onboarding system. Next, we have the uniform and consistent onboarding checklist. Always a good idea to have something that we can follow on a consistent basis. Anticipate turnover in that back office staff for the reasons I just mentioned. You want to be careful that the key persons who are responsible for hiring and onboarding follow the company system, not their own system. And then make sure that the hiring person strictly adheres to the established onboarding procedures and the driver file and record keeping systems without exception. And I emphasize without exception because many times companies will feel pressure to hurry up and get that driver in the seat due to shipper or customer demands. They might skip the pre-employment drug test or some other requirement just so they can get that load to where it needs to be. You want to try to avoid that at any and all possibilities because that type of policy or procedure can come out at the worst possible time, and that would be during that civil case. So for some of these items, whether it's establishing a driver qualification system, onboarding, contact somebody with Hub, namely the Hub risk services person that you deal with, and they can help you to put those items in place. Next slide. So when it comes to discovery, you want to make sure your compliance documents are at your fingertips. So you want to be familiar with and locate the following for any potential discovery demand: driver qualification files, recent driver DOT drug and alcohol test results, evidence of any prior disciplinary actions, evidence of any formal safety training, hours of service or records of duty status, RODS, up to the last 6 months. But I should also mention that when it comes to legal action, they're not limited to the regulatory record-keeping requirements. They could actually technically demand records in excess of 6 months or a year or two, and we'll let Robert comment on that here in a few slides. Vehicle and trailer maintenance files. Be careful, especially when it comes to independent contractors or owner-operators. You still have the obligation, if not the responsibility, to collect timely vehicle and trailer maintenance, service, and repair information. And last but not least, driver safety policies and procedures. You should take a look at any type of written policies or procedures 3 times a decade is a good suggestion. In a 10-year period, if you look over your safety policies and procedures 3 times, that would be pretty much making an effort to keep them up to date. So when it comes to these types of records, these are the things that can be demanded, but it's not the only list of items. There could be a lot of internal communications, emails, things of that nature. So the thing you want to keep in mind is get organized. Institute a system now before the accident occurs. This may sound like a pretty daunting type of assignment for you, but it's relatively routine when it comes to record keeping and timely maintenance of your documentation.
That's great information, Chris, and I'll tell you, you'll see how all this melds together here in a minute when John talks about how to handle a claim and something that Chris has mentioned has not been done, or when John's tried to handle the claim and now it's going to trial and Rob picks it up and the first question he asks you is, show me the records, and you're going, uh-oh. So that's why all this means so much together. We can't look at one piece of this. I'm going to turn it over. Anyway, we appreciate what you just told us, Chris. John, we'll turn it over to you now to take on the post-accident fundamentals.
Thanks, Jerry. Chris, thanks for setting the table like you did. You hit on some phenomenal points. So I want to talk about once the loss has occurred, and you're going to hear me mention time and time again a few words like consistency and immediacy and responsiveness. And I may sound like a broken record, but I'm sitting here thinking of my kids who just, I think the last Father's Day gave me a Father's Day card, and the Father's Day card was hilarious because it poked fun at the fact that us dads, we tend to use the same jokes or the same puns over and over and over, and the kids, you know, they laugh about it. Well, this card said, alluded to the jokes, and it said, you know, Dad, every single time. And that's the mantra from Chris and I so far, and I know Rob will support this. You've got to be consistent, because when you're not consistent, you know, the plaintiff's bar is going to find that as an opportunity. My first question is this. The term catastrophic is also used, or it has been used in the past. You know, nobody wants a catastrophic loss, but here's my question for you. What is catastrophic? Is it a $5 million loss? Is it a $1 million loss? Some fleets, it's $100,000. Some fleets, it's $100 when they don't owe it. That's catastrophic, because that's money being sucked out of their organization. So ask yourself the question, what is catastrophic to you from a financial standpoint? I'm going to cover a couple of basics very quickly here. Once a loss occurs, who should someone contact? Well, it's real simple. Everybody that's involved. Everybody that's involved. Your driver, obviously the other party that's involved, and every single occupant in that other vehicle. I don't care if it's a bus of 75 people or a vehicle with one. Everyone needs to be contacted, because everybody is an exposure, a financial exposure to you. Okay. Now, it's optimal that the motor carrier make that call. Why? Because it's you that was involved. It wasn't Jerry Gillikin, and it wasn't Rob, and it wasn't Chris, but your name is on the side of the truck, right? So, hi, I'm calling from XYZ Trucking Company. Has effect. Now, that may not be optimal. So then you shift gears and ask, well, is my insurance company or TPA, are they ready to do that in the manner that represents us the way we want to be represented? When? Very easy. Now, loss occurs at 2 o'clock on a Saturday morning. You better be mobilized to start collecting information and reaching out to people at 2:05. I mean, that's the optimal. Is it realistic? Maybe not. But every minute that goes by, the plaintiff bar has a better opportunity to get into your pockets financially. So you got to think about the efficiency and the cohesion of within your organization, between you and your driver, and also, most especially, the cohesion between you and your insurance company. You've got to narrow it down to the minutes and seconds, because time really is money in this business. How do you reach people? What do you do? Well, you pick up the phone. There's ways to find people in this day and age on the internet, and you can do a background check on people pretty quickly. What we like to do is, if we get a license plate, we do an immediate check. In most every state, you can learn who the registered owner is, and you go from there. I tell drivers, I tell organizations, if your driver does nothing else, get a photo of the license plate. Questions to pose. I like to say this. If you had one single question to ask post-accident, only one, what would it be? Just one. Here's my answer. Was the other vehicle occupied? Because if the other vehicle is unoccupied, or it doesn't involve another vehicle, you're not dealing with bodily injury. The whole nuclear verdict thing is right out the window. But if that other vehicle is occupied, I don't care what happened in the accident. I don't care if there's a scratch. I don't care if it was squashed like an accordion. You've got to respond immediately, every single time, like the card says. The other comment I want to make, let's go to the next slide, please. The other comment I want to make is, and this may steal a page from Chris's excellent presentation. Don't be obvious. When you don't have records, when you hire a driver that has no experience, you know, we heard about the verdict. I think it was out of Florida that was like $1 billion. I read that one of the drivers had like no experience. That's being terribly obvious. And you're setting yourself up for a nuclear verdict. That makes it really easy for the plaintiff's bar. Okay, conduct immediate, ongoing, in-depth investigation. Let me hone in on one thing. The ongoing investigation is an Achilles heel to the insurance industry, because typically a claim gets to an adjuster and they are tasked with everything. And they might call an independent adjuster out and they kind of shift the responsibility to the independent adjuster. I'm telling you folks, that's not enough. There needs to be a concurrent investigation going on. Concurrent investigation. What do I mean by that? Well, if you get somebody at the scene in St. Louis, somebody sure as heck better be on the internet trying to find out who those people are that you encountered. License plate, background check. Are they on LinkedIn? Are they on Twitter and everything else? Because you begin to paint a picture, and the bad characters are going to surface very, very easily, and then you better shift it into overdrive if you have a bad character that you're involved with, because they're litigious. They're already predisposed to hiring plaintiff counsel, and everything is going to be twisted, and that's why there's an urgency of you to button everything down, okay? I want to emphasize pictures. I've seen cases where, and Rob, you're going to hate this. I talked to a defense attorney in the Southeast somewhere, and he's all ready to go to mediation. And I said, do you have photos of the damage? He said, no. Are you kidding me? That's the physical evidence. There's nothing more important than photos of the damage. If it's a scrape or if you demolish the car, please direct your drivers to get photographs, okay? The money is in the injury, right? You can damage a Tesla or Mercedes-Benz, I don't care what kind of car. That's a finite number, right? But when there's an occupied vehicle and they can allege everything and anything under the sun, that's where we have to focus our attention, okay? Let's go to the next slide. And when an investigation is done, what we're really after is what really happened. I should have emphasized that word really in bold and red and flashing. What really happened? When a driver reports an accident and said, well, I moved from the left lane to the right and I scraped the car to my right, and there's no injury. Can't tell you how many times I've seen that. And the driver reports there's no injury. And the people at the motor carrier and the adjuster take that to the bank. The driver said there's no injury. I think we all know we cannot rely on that. Now, from the driver's perspective, there is no injury, and that's great. But when Susie goes home and talks to her cousin Sally, and Sally says, my friend Joe just got $100,000 from a truck accident, the wheels start to turn. And we don't know anything about that person that we're involved with. Their husband may have left yesterday. They may have lost a child yesterday. They may have been evicted from their home a month ago. You have no idea what they're about, right? So you just have to anticipate that you're going to have challenges. And if you don't, if the people are forthcoming and genuine, you're great, but you've got to be prepared to jump on these situations. So real quick, I have a picture of a car that was rear-ended. It's not the lightest of impacts, but here's what I like to describe to people. In an accident just like that, what happened biomechanically? What happened to the occupants? And there were two occupants in this car. What happened to them? And the animation is playing. So there's a recreation that takes place. We like to advocate doing this early in the life of the claim. Don't wait till litigation. You got to send a sailboat, a plaintiff counsel. We've invested in this case. It looks like you invested heavily. It's not that expensive, believe me. But you want to show your evidence. You want to play your hand early. Why? I don't mind saying this, to intimidate plaintiff counsel. They're going to look at this and see that you've invested time, effort, and money, and they're going to start to back off. I've seen it many times. There's no guarantee. There's never a guarantee. But many, many times you get them back on their heels, and you're better off in that position. One last comment here. In a rear end collision, when somebody said they were thrown forward into the dash or steering wheel, that's a falsehood. That's a major red flag. You always, last thing, you always move in the direction of the force. So if it's a rear end accident, you're going back. Back where? Into the head restraint. That minimizes the movement of the head and the cervical part of the body. There you
John,
go.
one thing I've heard you say to quite a few motor carriers to get their attention is when you give that same example right there, is you can say to the plaintiff attorney, this is the exact same impact as a sneeze.
Right.
And literally it kind of stops them in their track. But sometimes, by the way, it doesn't stop them in the track, and we have to have somebody, a good defense attorney, who can step in and be ready for this. And thus, let me have Rob take the stage and tell us about that. Thank you, Rob.
Thank you, Jerry. So you could really call my part of the presentation location, location, location. I sound like a real estate agent, but it's really the truth. What we know is in 1977, the Supreme Court allowed, under the Bates versus Arizona case, they allowed lawyers to start advertising. And what we see then is about 7-8 years later, we start to see verdicts uptick. They start to go up, and then they climb and they climb and they climb. And I'm sure you've all seen lots of advertising of the various lawyers on TV. Trucking companies and transportation companies have now kind of been a target of that because a lot of the lawyers using reptile tactics and things like that have determined that, hey, this is low-hanging fruit that we can go after a lot of these characters. But there are lots of factors that go into driving nuclear verdicts. And I'm going to talk first a little bit about the legal framework and then talk about some specific circumstances that you see here on the slide that can increase awards. So generally speaking, in the United States, there's 3 different kinds of fault systems, and these vary from jurisdiction to jurisdiction. There's what's called contributory negligence or contributory fault. Generally, that is the proposition, legal proposition, that if a plaintiff is even a small bit at fault, they're barred from recovery. Then there's what's called comparative fault or comparative negligence, and that means if a plaintiff is partially responsible for injuring themselves, that partial fault will reduce their award. Then there's what's called modified comparative fault or modified comparative negligence. That's where the plaintiff's fault will reduce the award, but generally by some legislative created threshold, it'll bar them from recovery. And that's usually if the plaintiff's fault exceeds 50%, they don't get any recovery at all. And so why that is significant is from jurisdiction to jurisdiction, there are different types of liability scheme. There's what's called joint liability, and some of you may have heard of this stuff before, but there's joint liability, there's several liability, there's joint and several liability, and there's modified liability. What joint liability means is that each of the folks involved in an accident are jointly liable for the whole award. Several liability means that as a defendant in a case, you're only responsible for your proportionate share of the award. Joint and several liability means that they can come after you or anybody else in the case for the entire award, and then you can go after the other people to get contribution. And you can see for obvious reasons why this is important to transportation companies, because even in cases where you may be just a little bit at fault in some of these jurisdictions that use joint and several liability, you can be responsible for the whole entirety of the damages and have to go collect against somebody else who is more at fault but may not be able to pay an award. So that's kind of the legal backdrop. So the American Transportation Research Institute, and this gets me to my slide here, they analyzed over 600 cases across the United States, looking to see if they can identify key metrics that drove large verdicts in the trucking industry. And what they did is they found there are a variety of cases. And so they analyzed these over 600 cases, and they found, as Jerry pointed out early, that awards over $1 million have increased dramatically over the past 14 years. For example, when you go back and look at the data, there was only 4 cases in the entire country in 2006, only 4 cases in the entire country that exceeded $1 million. By 2013, that number had climbed to over 70. And what they found is that there's a large spread in these verdicts with lots and lots of outliers. But if there was the accident involved a traumatic brain injury, on average, that would increase the award, and it would increase the award rather significantly. It would increase it by more than $800,000, all things being equal. In addition, to things like death and traumatic brain injury and things like that, the length of time that a crash occurs and a claim is resolved and a suit is resolved, for example, that increases the amount of exposure and the amount at issue by $120,000 per year. So it's important to get on these things early and try to get them resolved, because for each year that goes by, on average, it's going to cost $120,000 more. By and large, across the country, when they look at verdicts and large awards and settlements, and this is not going to surprise anybody, but injuries to children or death of children was the single largest factor in driving nuclear verdicts. When a child was seriously injured or killed, mostly these involved child death cases, it increased the amount of exposure on average to 27 million for every child that was injured and killed. In addition to injury factors, right? In addition to sort of the crash characteristics, there were also litigation factors that drove awards and higher jury verdicts. One of the most interesting is the presence of experts. If the defense hires experts in the case to testify, generally speaking, that decreases the award over $800,000. If the plaintiff and the defense has an award, has experts, that will decrease the award by $300,000. And if just the plaintiff has an expert and the defense has no competing experts, then what you'll see is it generally increases the award by about $500,000. So let's go ahead and jump to the next slide, please. So we're talking about location, and here's a map of the country, and what you'll see is there's some states out there that have 100% plaintiff verdict areas, and there's some states that have lower plaintiff verdicts statistics. And just want to talk about a few things here. Some of this is related to the sample size. For example, Oregon did not have that many transportation industry type cases that went to verdict. But what's interesting about this is some jurisdictions seem to be more friendly to the trucking industry. For example, we see Alabama, there was nearly a 92% success rate for the defense in those cases. Now, some can tell you that's because the defense lawyers down there are picking good cases and settling the bad ones. But then you take a jurisdiction like California, where you've got over 97% of those cases tried, the plaintiff gets a verdict, versus a Texas where it's closer to the middle, where they had about a 50-50 split there. By and large, Texas had the most verdicts tried, trucking industry verdicts tried. You see down there about 86 cases in the survey period. So jurisdiction and the law in the jurisdiction, as you can see, clearly matters. Next slide, please. So the American Tort Reform Foundation publishes a document called Jurisdictional Hellholes. And this is available online if you want to go read the report. It's actually kind of some interesting and fun reading, but it's available at judicialhellholes.org. You can download the entire report and read it. But what the ATRF has done is, since 2002, they've analyzed various jurisdictions around the country. And what a judicial hellhole is it's basically a jurisdiction that applies laws and court procedures in an unfair and unbalanced manner, and generally that will be to the disadvantage of the defendant. Painting with a really broad brush, what you see here is the offender list are jurisdictions that are known for excessive verdicts, permitting creative and expansive liability theories, and not really being concerned about whether or not the case is in the right venue and things like that. I'm going to talk about two jurisdictions here in particular, and those are Louisiana and Georgia. But before I do that, it's important for all of you out there to know, and I suspect many of you may know this, but generally in the United States, where you're involved in the accident is where the suit's going to be filed, and generally that is the law that's going to be applied to the accident. So that's important as you're evaluating your exposure and trying to figure out, you know, what you should do and what the liability is. But I mentioned I want to talk about Louisiana and Georgia for two reasons. One, Louisiana is a state that's kind of known for lawsuit abuse and scams, just to be honest with you, and insurance scams. And one thing in particular that happened in the survey period was there was a scam that was actually specifically targeting the insurance industry. And this goes back to some of the things that John was talking about and the importance of taking photos every time. What this scam involved was essentially fake crashes with an 18-wheeler. There was a fella in Louisiana that was working with a lawyer down there, and he would load up a car with people, and they would either get in a very low speed crash with a truck or a no contact crash at all. In total, they staged over 31 accidents in fake accidents where there was no real damage to either vehicle. Many times the driver didn't even know he'd been in a crash. These resulted in hundreds of thousands of dollars in settlements, hundreds of thousands of dollars in claims and litigation expenses for the transportation industry in Louisiana. And that's one of the reasons it's made it on the list. So to underscore what John said earlier, it is important to always get photos so you document what the condition of the vehicles are. Talk about Georgia for a minute. The reason that Georgia has made it on the list here is because it has become, there's rampant advertising in Georgia these days, and the trucking industry in particular has been a target for nuclear verdicts in Georgia. In the survey period we're talking about, there was a $280 million verdict out of Columbus, Georgia. And two things I want to talk about in that. One, going back to Jerry talking about fatigue, one of the themes in that case was driver fatigue in that case. So one of the factors that drove the large verdict in that case was the plaintiff using reptile tactics to argue that the driver was fatigued. One of the other things, of course, was that case involved it involved death as well, and large non-economic damages were awarded. Another case out of Georgia that landed it on the list was essentially a medical emergency case where the driver had a medical emergency and he was unresponsive after the accident. He hit somebody. Initially, the verdict was for $15 million. Later, it was discovered, to go back to Jerry's Dirty Five list, it was found out that the driver had opioids in his system. So what happened then was, once the jury heard that, they awarded damages up and above that, and the verdict went from 21 million to 15 million. So all of this stuff is important to know because it helps you determine what you need to do. In addition, I just want to mention a couple of things that Jerry's going to talk about here next. But Hub has an online portal, Hub Drive Online, that has numerous resources that can help you with compliance and things like that. That helps set the stage so that when accidents happen, because they're inevitable, you're in a best position from a documentation and a management standpoint. In addition, and I hopefully have a chance to talk about this in a minute, but my time is up. I'm a lawyer and we tend to talk over our time, as you all probably know. but Hub also has a really attractive excess liability policy that with where verdicts have gone, takes into account most all of the verdicts out there. It'll put you in a position where you're in a pretty good situation to have enough coverage to protect you from all but the outliers. So Jerry, back to you. Thank you.
Thank you, Rob. That's good information. I actually have got a couple questions that have come in already, so I'll talk to you about those when we get to the question period. I feel like I'm at the Oscar Awards where they went ahead and moved the slides. I think that's our sign to say it's time to keep moving. I'm not sure, but I think that's what it means. So let's go to the next slide. We've talked about a lot of things here today. What we really want you to see is that we are not just telling you about nuclear verdicts. We're trying to show you how we're going to help get you prepared so we can fight for them. The things that Chris has said can help you be in the right position so John can handle the claim. And when he can't handle it successfully and quickly, we have an attorney who can pick up all the pieces that we've done correctly and make it seamlessly work, where the plaintiff attorney says, let's go take an easier one. As John had pointed out before, the plaintiff attorneys don't want to have a lot of pushback. They're trying to get their quick dollars and move on. Rob, thanks for mentioning Hub Drive Online. We're teasing you with it today. We've talked about a little bit about it. I'm hearing it more and more around the country. It is something that we're coming out with soon, a very powerful risk management platform that can help in a lot of those areas we talked about today. Because when you're not handling those issues, those are the things that can bring your company down. Things like improper onboarding, negligent hiring, etc. Your contracts. So the Hub Drive Online that we're going to be rolling out, we'll have a webinar on it soon, will help you do a lot of those things so you don't have to remember to do them. I picture myself thinking, wouldn't it be nice to have a consultant that came in every day or every other day randomly and said, let me check your shipper files. Let me look at all drivers with letters between A and F. I want to look at all their files. Let me check let's go out and check 4 trucks right now. Well, what if somebody did that every day? That's the kind of thing we're trying to do with Hub Drive Online. We're trying to have you prepared so when there's an accident, as Rob just said, there's going to be an accident, that we're prepared to do step 1, 2, or 3. We already know what to do. We know what we're going to find when we get there. How great would that be, John? When you open the file and you say, oh, great, I got a good driver. Well, it's not always going to be a good driver because we've already checked it. So to that point, and the other point that Rob brought up for me was today we do have a Hub Drive Excess Liability Shield. It's a new program, an excess program that we're actually providing for our clients. You know what? There's plenty of people out there offering excess. That's okay. It costs too much. It takes too long. It may be good. It may be bad. It may not cover everything you need. There may be minimum premiums that a lot of truckers can't buy it for that reason. So we're just trying to simplify all that by saying if you're one of our customers, we're going to be able to get you a quote really quick. The minimum premium size is like $1,500. I mean, it's almost nothing because almost any trucker can afford it. That's what I'm saying. It's not a big barrier to get in. We can offer up to 5 million limits, and it can be for any kind of transportation, couriers, any truck out there that's doing this business. So we want to ask you to ask us more questions about it, and we can't wait to tell you more about it because I think it will solve a lot of the little problems that are out there today. As part of Hub Drive Online and us being able to offer the access program, those things that we're offering are already made in there. So the insurance company feels better about it, and you feel better about it. We're already doing things like doing your contract reviews, guarantee and immediate claim service. So as we're doing those, we should have better success with what we're doing with excess. For sure, by doing all these things that Hub Drive Online is going to offer, we're going to be able to handle the claim better and prevent the lawsuits. When we have a lawsuit, it's going to be much easier for the Rob Thornbergs of the world because he's going to walk in with his chest out saying, I'm ready. We're ready. We know what we're doing. All right, so next slide. I was trying to get to the questions because as we've been talking, we've got a lot of questions. So we'll hit the high notes to see how much time we have. And by the way, Rob, this is a question for me. So I always wonder, you're talking about jurisdictions. How does it seem like the plaintiff attorney is always able to change it where they want it, but we never can change it? Am I wrong?
You're not far off. A lot of those places that exist, a lot of the jurisdictions have favorable laws that allow the plaintiff to sue. And most states have preferred venue provisions, most jurisdictions. And so generally speaking, a plaintiff can sue you either where they live or where the accident happened, painting with a really broad brush, right? So what that means a lot of times is that they can sue you, in places that maybe are far from your home base or your terminal where you have any operations. And some of the other hellholes you saw on the list there, they're actually known for forum shopping venues where people just file suits there, and the courts really don't care whether the suit has any nexus to it at all. And that's one of the reasons that they find themselves on the list year after year. So
I hate there's a name for that, shopping venues.
Yeah, forum shopping.
John, this question is for you. It says, John, I understand you do a fair amount of claims audits and claims reviews for trucking companies. Can you share a few points that you typically find in a claims review?
Sure. I'll try to make this brief. On the downside, I guess, or to help the audience, what we see a pattern of is, and I just looked at a file yesterday, it was a rear end accident near Chicago. It was Cook County. And the allegation was that we got rear-ended, but that we changed lanes left to right quickly and the claimant rear-ended us. I mean, think about that for a second. Trucks aren't that nimble. And there was no fight in the file with plaintiff counsel that we don't owe this. We have favorable liability here. And then, and amazingly enough, there was no inspection of the claimant vehicle and no inspection of the truck, the rear of the truck. So that's one of the fundamentals. The other thing I would say that we see too much of, there's a concept called anchoring. That's when, unbeknownst to us as consumers, a price is put in front of us and we get fixated on that price. It happens when you buy cars and homes and things like that. It certainly happens in claims. And here's the problem. Adjusters, busy as they are, call plaintiff counsel and ask them to send a demand, which I term it this way. Hey, Mr. Plaintiff Counsel, if you could get around to it, why don't you send me over a really, really ridiculous number that we can consider? Because the number never makes sense. They pull a number out of the sky, right? So we sit back, the industry has a tendency, not all the time, to sit back and wait for a demand instead of doing your job, doing the investigation, knowing your liability, the venue, the damages, and all of that sufficiently to say, Mr. Plaintiff Counsel, this case is worth X, here you go, and have a lot of teeth behind that. So we're still very, very reactive, Jerry. That's how I would term it in summary.
Okay, thank you. That's something good to think about. Chris, this has to be something you can handle better than the rest of us. This question is, my DQ files are older and haven't been updated as required by the regulations. Hopefully this guy didn't leave their name. What do you suggest we do to get the record keeping back on track?
Unfortunately, it's a common scenario. And when it comes to driver qualification files, there are certain forms that are required to be kept per the Federal Motor Carrier Safety Regulations. And sometimes those records, those forms get outdated, or too many are collected, or they weren't properly completed in the first place. So the rule of thumb from the enforcement side of the issue is to be proactive and make a good faith effort. And it's okay to make notations in that file that as of October 1st, you are in the process of updating all of your driver qualification files and getting new forms and documents prepared. The more you tell the story, the better it'll be for you, if not on the enforcement end, and certainly on the litigation end. So when it comes to records that are outdated or improperly completed, make the good faith effort to update them. Good example would be a driver's employment application. That is a requirement, not a general employment application. So if your company has not converted to a driver's employment application, that would be a good place to start. But that's basically the advice.
Okay, well, I appreciate that. I'm jumping to this question, and it's going to end our session because it's too broad of a question for us to do in 2 or 3 minutes. But we're going to try our best to give a little input on it. They said, how much insurance should somebody motor carrier carry? Well, I'm going to give you my answer first, and Rob, I'll ask you next. And John and Chris, you be thinking about your answer. The requirement is $750,000 today, right? So, John, you mentioned people put out crazy numbers, and that sets the baseline. Well, there's a representative, Garcia, who's now asking for 4.9 million. He said that's where we should be, 4.9 million. It should be the required limit for everybody. That's a ridiculous limit. It won't get there, don't worry. But he has set that number out there, and everybody's looking at it. By the way, this has been tried 2 or maybe 3 times already, and it hasn't worked. But it is getting to the public going, well, tell me more about that. So let me tell you more about it. It's in 1980, 4 decades ago, we came up with, or someone came up with 750,000 limits of the requirement. Hasn't changed since. No one wants to talk about it, but it's not enough. I mean, if 750 was the right number, then it certainly isn't the same number 4 decades later. A car back in 1980 cost, I don't know, I'm not as old as John, 5,000 or 10,000. Yeah. But it costs a lot more, and it costs 4 times as much today. And medical or hospital visit, it's bound to cost more than 4 times as much. So the limits probably, I mean, what you should carry should go higher. I don't want the government to tell us what we have to do, but I think you should have more. And I would say the next step from $1 million is $2 million. And I say $1 million because insurance companies, even though it's required at $750, they offer a $1 million limit 90% of the time. So I think $2 million makes a lot of sense. And by the way, our excess shield might be able to help you get it faster and easier than you thought before. That might be a good possible solution. One other thing, we were talking about, people say, and Rob, I'll let you address this, but well, this is going to sue you for what limits you have. If a truck line has 10 or 15 tractors, which a lot of times means they'll have 30 trailers, Well, they've got $2 million in assets right there if it's paid for. That's $2 million in assets. If you have $1 million in insurance, they're going to take your assets that you've already paid for. So there's another reason to have some excess. But I could ramble on forever. Rob, let's see if you can give me an answer in your opinion.
Yeah, I'll go a little higher than you, Jerry, and here's why. The average verdict over the last 15 years has gone up, and it's $3.1 million right now. And so that's the average plaintiff's verdict across the country. The median is 1.75 million. When the ATRI looked at all the cases I was talking about earlier, 83% of the verdicts fell within a range of 0 to 5 million. That 83%. So my answer to people when they ask me is I would tell them to get 5 million. And the reason for that is at 83, that covers about 83% of the verdicts. That's pretty good coverage right now for everything. And that only leaves you with this about a 16.6% exposure above that in terms of risk. And really most of those cases are the catastrophic cases like we talked about in Florida, or the $280 million case in Georgia, which frankly, unless you're going to have, insurance from insurance towers, and it's unrealistic to have exposure for those super, but something in that range will cover you for 83%, which is what I always recommend to my clients is, get up to 5 million. And that's not all you need, but that's a reasonable amount of coverage. But
I'll add that Rob insures or handles a lot of very large trucking companies, and they can afford 5 million limits. Many of our customers can't afford 5 million limits. But I'll tell you, here's one thing you can do with that money. Instead of buying 5 million limits, you can listen to what Chris and John and Rob said earlier, because that will keep you out of those courtrooms. And when there's a case against you, it can be settled because you've given us some ammunition. All right. So John, what do you say?
If you're going to buy only 1 million, and I'm speaking as a former employee of a couple of large truck lines. Okay. So I'm the buyer. You can be comfortable with 1 million to the extent that you listen to Chris and you have a very highly responsive claim organization, whether it's in-house or your third party, okay? Because you're going to reduce the likelihood of litigation if you do these things. That's the key, reduce the likelihood of litigation. You got to be quick and you got to be creative. And to Chris, again, you've got to be very thorough with your documentation. And as I said earlier, don't be obvious. However, if you buy only one, I suggest you have some money in reserve for that rainy day. When there's a case that is total sympathy, and I had this near Joplin, Missouri, where a decorated war veteran did something stupid, absolutely stupid, on an interstate. And he was a pedestrian trying to help someone who had a flat tire, and his own car struck him and killed him. That was a very, very sympathetic situation. The owner of the trucking company, who had only 1 million, dipped into his pocket to the tune of $200,000 to settle that case. That's what needed to be done. So if you're only buying 1 million, have some money in reserve for that bad case. But if you're asking me what amount makes sense, I would say 2, because 1 million, as we all know, doesn't go as far as it used to. But I'm going to come back again. Look at your processes real quick. And if you're not comfortable, then you're going to need the insurance.
All right, Chris, you got an answer for us?
My 2 cents worth would be we need to acknowledge the outlier fleet. And by that, I mean the hazmat haulers, hazardous materials. They're required by regulation to carry the higher $5 million limit. Not for every type of hazmat, though. Certain classes and divisions of hazardous materials require the higher $5 million limit. So on the opposite end, I would agree at least 1 million. And certainly the experts like Robert and John are convincing me, and yourself too, Jerry, convincing me that 2 million might be the lower limit to consider.
Okay, I appreciate that. I think with that one really wide question we could talk about for another hour, we did run out of time. But look, first of all, I want to thank everybody who sent in the questions and for joining us. I would thank the panelists for answering all these questions. And want to appreciate everybody for joining us today, and certainly appreciate Rob Thornburg, John Liberatore, and Chris Easley for taking the time to do this. I I would like to do it again. I'd like to do more of it because I do see us helping the industry by doing this. So if y'all are available, we may ask you again. Well, thank everybody. Thank you.
Thank you.
Thank you.